Good evening or morning or afternoon, whatever the hell it is, man. I've had a headache all morning, so I've been like kind of laying down, but breaking news happens, and when breaking news happens, I happen. I don't know what that's supposed to mean, but yeah. So what's up, Wolverines? How are you doing? Pasha Weevil. That is a very interesting name, and I love the chicken icon, by the way.
How?
Silverback, tactical and defensive out there in state. A bunch of people, MC, Live Life, the Sentinel, Warfall Patriot, Damien.
I'll let you know, I now identify as Cherokee. How?
I am part Cherokee, right? Probably why you identify as part Cherokee.
That's exactly why, because we're...
I was going to make the I'm a hoe isn't an Indian tribe joke, but...
Dudung.
Yeah. Yep. A lot of Cherokee and my family. But let's be on the point.
Lots of Cherokee.
Yeah, my grandmother...
Like Elizabeth Warren?
No. It's actual...
My grandma killed a Nazi, okay? All right.
Yeah, that's pretty cool.
You want to go grandma for grandma?
My grandma was a Nazi.
That's dark grandma killed. That would be interesting. But let's go ahead. Basically, last week we had a ruling out of California. A federal court ruled, a federal district court, and a Biden appointee ruled that switchblades are not protected arms. He did a lot of bunk. He changed dangerous and unusual to dangerous or unusual and a bunch of other stuff. But today we have some good news. This is the Supreme Court of Massachusetts, and they ruled that switchblades are protected arms. The state of Massachusetts, on the other hand, tried to argue that switchblades are not arms at all, and the right to bear arms only applies to firearms, which would change the whole entire understanding of the Second Amendment if the...
Okay, well then why do you need to get a FOID card in Mass? Why is no one legally allowed to own ammunition without, going through, like they can't make these arguments and then carry the policies that they do. That's absurd.
All right, this case is Commonwealth versus Conjura. The Commonwealth, of course, is the Commonwealth of Massachusetts. So let's go ahead and read this. I'm going to kick it off in dark.
Actually, we took a poll, and apparently people prefer to listen to Rich read, but I'll go ahead and start. So start right here at the top. Notice!
No, just start down here.
Oh, okay. Sorry. Constitutional law. Right to bear arms. Evidence. Knife. Practice. Criminal. Dismissal. Words. Arms. Common use. Dangerous and unusual weapons. Or CRS, we love you. He used the terminology affray. Complaint received and sworn to in the Central Division of the Boston Municipal Court Department on July 6, 2021. A motion to dismiss was heard by James M. Stanton, J., and a conditional plea was accepted by him. The Supreme Judicial Court granted an application for direct appellate review. Caitlin Gerber, Committee for Public Counsel Services for the
All right, this
defendant.
is just going to list a bunch of people, so skip that.
Okay. And start at George J.
Yeah.
George Jefferson, since 1957, blah, 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 has prohibited people from possessing certain spring release pocket knives, commonly known as switchblades. In this case, we are asked to decide whether prohibition against carrying a switchblade knife violates the Second Amendment to the United States Constitution. Considering the United States Supreme Court's decision, New York State and Rifle, basically Bruin, we conclude it does. Accordingly, we reverse the denial of the defendant's motion to dismiss. Background: we summarize the agreed upon facts relevant to this appeal. On July 3rd, 2020, Boston police officers respond to an altercation between a couple at Temple Place in Boston. They found the defendant, David E. Kanhura, standing in front of his girlfriend, seemingly preventing her from leaving. The officers spoke with them individually. The girlfriend reported the defendant had taken her phone and would not return it. Two witnesses also reported seeing the defendant grab his girlfriend and push her against a wall.
So this guy's probably not a good person.
Yeah, most likely dirtbag.
All right, Rich, take over from there.
The officers arrested the defendant and searched him incident to the arrest. During the search, the officers recovered from his waist an orange firearm-shaped knife with a spring assist blade. The defendant subsequently was charged with carrying a dangerous weapon. For the record, for the recovered knife and assault and battery on a family or household member.
All right,
Defendant-
stop right there. You might say spring assisted. That's not a switchblade, but under Massachusetts law, it's considered a switchblade.
Okay, that's exactly what I was going to ask, because there is a difference between spring assisted and spring operated. So in Massachusetts law, is even spring assisted.
Yeah, it doesn't
knives.
make it doesn't differentiate between a spring assisted and spring operated.
Wow, interesting.
All right, keep on going,
The-
Rich. I wanted
The
to make
defendant
it clear
conce-
for people.
The defendant conceded the knife met the definition of switch knife, or any knife having an automatic spring release device by which the blade is released from the handle. Nevertheless, he challenged the constitutionality in pretrial motion to dismiss. The defendant argued that because a switchblade is an arm, prohibitions on carrying a switchblade violated his Second Amendment right to bear arms for self-defense. After a hearing, the judge denied the defendant's motion to dismiss. The defendant then tendered an admission to sufficient facts for a finding of guilt on the charge, while reserving the right to appeal from the denial of his motion to dismiss. And blah, the judge accepted the defendant's tender and entered a continuance without finding for 6 months, placing the defendant on administrative probation. The assault and battery on a family or household member charge was dismissed at the Commonwealth's request. The defendant appealed and was allowed for his application for direct appellate review.
All right, let me just stop you here. So basically, he said, I will plead guilty to this, but you have to let me appeal the pretrial motion that to dismiss that you said that you denied, and the judge agreed to it. The Commonwealth decided this guy's not going to win on appeal, so we're going to drop all the charges and just hit him with discharge because he's already appealed. He already said he's guilty of this, so we're going to drop everything else because we got him on one guilty charge, so we don't have to worry about the rest because that's how sure they were going to win.
Wow. Let's see. Member was dismissed. The defendant appealed and was allowed his application for direct appellate review. The defendant contends, but this violates the Second Amendment right to keep and bear arms by criminalizing the carrying of a switchblade knife. The defendant's constitutional claim presents a question of law, which we review de novo.
I want to clarify something right now. So the Kershaw Kin Onion Design 1, that you actually have to push the blade to get it going.
which is different from spring operated.
Yeah. But you have to, since you actually have to manually operate the blade, I don't think that falls under.
But we have to remember that this is what we're talking about is Massachusetts state
Yeah,
law. So,
but I think the Kin Onion Design 1, the way it's designed, I don't think it would be banned in Massachusetts.
well, spring assisted would be a if there's any spring, even if you're only manipulating the blade.
No, but the if you manipulate the blade only, I think it's legal in Massachusetts.
Wow, to my understanding, that's like the literal definition of spring assisted because
We need
No,
the government out of our pocket.
They have
Yeah.
the other ones where you don't do the blade. They have the little nub, and
Hmm.
it's questionable. All right, keep on going.
Interesting.
You got to scroll.
Oh, all right.
Whoever
That just goes over the law.
the Second Amendment provides a well-regulated militia. Sounds familiar. Being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Supreme Court has concluded the prefatory clause, a well-regulated militia being necessary to the security of a free state, does not mean the right of the people to keep and bear arms depends on service in the militia. See Bruin, Haller, blah. Rather, the central component of the Second Amendment is inherent right of self-defense, which is a guarantee to all Americans the right to bear commonly used arms in public, subject to certain reasonable, well-defined restrictions. See the asterisk in the Second Amendment. John, are you writing a book?
No.
While Heller and Bruin involved handguns, Second Amendment protections subsume more than just firearms. See Catayano versus Massachusetts. Stun guns constitute arms under the Second Amendment. Indeed, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Heller. Bruin requires that we employ a two-part test to determine whether a regulation or restriction passes constitutional muster under the Second Amendment. First, we must determine whether the Second Amendment's plain text covers the individual's conduct. If the regulated conduct falls outside the scope of the Second Amendment, our analysis ends. If, on the other hand, we conclude the
All right, we
regulated
can just
conduct,
this basically, I talk about this a
Bro.
lot. It has to be consistent with the text, tradition, and history. If it's consistent with the text of the Second Amendment, that's the first step of the Bruin test, and it moves over to tradition and history, where the state has to provide analogs to show that their law is consistent with the history of firearms regulations in the country. So that's what. So we can skip that. Just go down to application. Dark, you can start reading here.
Application A, step 1. The defendant argues a switchblade at root is a type of folding pocket knife, and law-abiding citizens didn't sound like he was engaging in law-abiding behavior at the time, but law-abiding citizens.
But you know what? They dismissed the charges, so therefore he's law-abiding.
Hey, I'm all about it. And law-abiding citizens have possessed folding pocket knives for lawful purposes since our nation's founding, including for self-defense. Therefore, notwithstanding its spring-loaded opening mechanism, a switchblade is an arm under the Second Amendment. The Commonwealth contends knives categorically are not protected by the Second Amendment, because the definition of arms is limited to firearms. The Commonwealth is incorrect. As discussed above, the Second Amendment extends to all bearable arms and is not limited to firearms. See Heller.
That has been the understanding of the Second Amendment since the beginning. Massachusetts tried to shoehorn a new definition of the Second Amendment in there because they knew they're going to lose.
Yeah. In evaluating whether switchblades are arms entitled to Second Amendment protection, we are guided by the Supreme Court decision in Heller. There, the Supreme Court analyzed the plain meaning of the term arms, observing its 18th century meaning is no different from the meaning today.
Yeah, basically what they did is they looked at the definition of arms from 1791, the ratification date of the Second Amendment, and said that knives are included in arms in 1791, so therefore they must be included in arms today.
The Heller Court provided two 18th century definitions of the term weapons of offense or armor of defense, as defined in the 1773 edition of Samuel Johnson's dictionary, and anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another, as defined in Timothy Cunningham's 1771 legal dictionary. The parties do not dispute switchblades fit these dictionary definitions of arms. Like handguns, a person can carry a switchblade for offensive or defensive purposes in case of confrontation.
Yeah, and that was the definition in 1791 when the Second Amendment was ratified. So the definition didn't change between 1773 and 1791. So if the founding fathers wanted to disavow knives and only concentrate on firearms, they would have used the term firearm instead of arms.
Yep, facts. To assess whether the drafters would have intended the term arms to include switchblade knives for Second Amendment purposes, however, we must employ Heller's methodology centered on constitutional text and history. See Heller. A review of the history of the American colonies reveals that knives were ubiquitous among colonists who used them to defend their lives, obtain or produce food, and fashion articles from raw materials. See State versus Delgado, blah, blah, blah. Does that say Newman or?
Yeah, just go from here, the colonial and
Okay.
Revolutionary War era.
In the colonial and Revolutionary War era, colonists typically owned or were equipped with hatchets, swords, and knives to use in their defense. Although swords and daggers were the most common bladed weapons, 17th and 18th century Americans also carried smaller knives with 3 to 4 inch. Guys, 3 to 4 inches is not average, despite what you hear. 3 to 4 inch blades that were used for self defense, hunting, and trapping. How would you trap with a knife? Well, whatever.
I guess you trap and kill it.
Yeah, you could kill after trapping it, I guess.
Well, you can also use it to actually shape wood.
Yeah, you could make the trap with, yeah, okay. Of the many varieties of knives, the folding pocket knife played an important role both as a tool and a weapon. Indeed, as America developed and its frontiers moved inland, the folding knife increased in popularity enough that it became an almost universal accessory. By the way, how many of you guys out there carry folding knives with you every day? Put a 1 in chat.
Mm-hmm.
1 in chat. Okay, so let me see. Almost universal accessory.
By the early 1700s, when eastern seaboard had become a highly settled area with large towns and cities and relatively good roads, men normally
carried a folding bucket.
A rich takeover.
Contemporaneous sources refer to the 18th century folding pocket knives as pocket knives, folding knives, spring knives, clasp knives, jackknives. See Newman at 231. Most were single-bladed with or without a holding spring and had simple metal handles. The term jackknife appears frequently in American colonist documents. American Knives, the first history and collector's guide. Early jackknives were large single-bladed knives ranging from 4 to 6 and 1/2 inches in length when closed. A particular type of jackknife, known as the Barlow knife, is mentioned in American records at least as early as 1779 and seems to have been in general usage at the time. In short, folding pocket knives only fit within contemporaneous dictionary definitions of arms, which would encompass a broader category of knives that today includes switchblades. But they also were commonly possessed by law abiding citizens for lawful purposes around the time of the founding. Setting aside any question whether switchblades are in common use today for lawful purposes, we conclude switchblades are arms for the Second Amendment purposes. Therefore, the carrying of switchblades is presumptively protected by plain text of the Second Amendment. We now turn to whether blah is consistent with this nation's historical tradition of arms regulation. Step 2. Again,
All right, hold on there. So I want to just point out the difference between the California Switchblade ruling that came out a few days ago. The judge, I ignored the for lawful purposes thing and said, "Oh, I'm only considering in common use for self-defense, and when I'm disregarding for lawful purposes." This court correctly applied it in common use for lawful purposes.
in other words, I will state any fact I want to make me seem right.
Yeah. Like
Again,
keep on going.
Again, even where a class of weapons constitutes bearable arms, presumptively protected by the Second Amendment.
Oh, let me just put in there that is showing that they're saying that the defendant in this case has proven that the law is not consistent with the text. Now it moves to step 2, which is tradition and history.
The government may still justify its regulation by demonstrating the regulation is consistent with our nation's historical tradition. At the second step of the analysis, Bruin requires us to determine whether a challenged regulation addresses a general societal problem that has persisted since the 18th century. If so, the lack of distinctly similar historical regulation addresses that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. The Commonwealth may meet its burden of pointing to analogous regulations enacted close in time to the ratification of either the Second Amendment in 1791 or the 14th Amendment in 1868.
I don't like
Here,
that. I think the whole entire 14th Amendment 1868 thing is a way to expand the time period. I think
yes,
the founding era is 1791.
correct. I agree. Here, the Commonwealth attempts to meet its burden by pointing to 3 19th century cases upholding statutory restrictions on certain types of knives, arguing these cases demonstrate a historical tradition of regulating certain knives. We are not convinced. Wow. Although the appellate courts in the cited cases upheld the state laws prohibiting the carries of certain types of knives, none involved in regulations of folding pocket knives, let alone switchblades.
What the
While-
next they're talking about, the state of Massachusetts tried to use the 1830 Tennessee law on Bowie knives.
While it is true the Commonwealth is only required to identify well-established and representative historical analog, not its historical twin,
That came
The
from
most-
our Amy case.
the most apt historical analog of modern-day switchblade is a folding knife, and a court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation to the modern circumstances. Thus, these cases are in opposite because they involve historical regulations of categorically different types of bladed weapons. Beyond these cases, the Commonwealth does not identify any laws regulating bladed weapons akin to folding pocket knives generally, or switchblades particularly, in place at time of the founding or ratification of the 14th Amendment.
Basically, what they're saying is that the Bowie knife is too different from the switchblade because the switchblade is more akin to a folding knife than a switchblade, and the state did not offer any examples of a folding knife being banned.
Accordingly, the Commonwealth has not met its burden of demonstrating a historical tradition of justifying the regulation of switchblade knives. Notwithstanding the foregoing analysis, the Commonwealth contends that the Second Amendment protection does not extend to modern switchblades. They are not in common use today for self-defense and are dangerous and unusual, weapons primarily designed for stabbing others. We disagree and discuss each of these contentions in turn. The Bruin majority reiterated the Second Amendment protects only the carrying of weapons that are in common use at the time as opposed to dangerous and unusual. Heller, blah. To determine whether a weapon is in common use today, most courts have chosen among three statistical approaches: raw numerical commonality, examining the total number of a particular weapon; proportionate commonality, examining the proportion of a broader class of weapons that are the specific weapon in question, such as the percentage of firearms that are assault rifles; and jurisdictional commonality, examining the number of states that allow the possession or carrying of the subject weapon.
Assault rifles are fully automatic weapons. I think they're trying to talk about assault weapons, which I don't like the term either. But
Right.
Yeah.
whatever.
Yeah.
But
There is
California
considerable
judge in the Switchblade case chose not to use any of those and chose to use, even though that knife rights gave all three of those, they chose to use something that they made up.
yeah, it's like stick my finger in the wind. There is
I mean,
considerable variety across the circuit as to the relevant statistic is and what threshold is sufficient for showing common use. For purposes
Dark,
of
you're
this
in.
case,
Rich, slow down, man. All right.
Dark, you're
I'm
in.
kidding. For purposes of this case, we conclude switchblades meet the common use test. Today, only 7 states and the District of Columbia categorically ban switchblades or other automatic knives, and only 2 states impose blade length restrictions of less than 2 inches. From these facts, we can reasonably infer that switchblades are weapons in common use today by law abiding citizens for lawful purposes. More specifically, we can infer they are widely owned and accepted as a legitimate means of self-defense across the country. Then it drops some case law. Turning next to the dangerous and unusual standard, many courts have treated the common use standard and the dangerous and unusual standard as 2 sides of the same coin. Cites case law again. Other courts have drawn distinctions between these 2 standards. For example, while the common use standard may focus on a statistical analysis of commonality, the dangerous and unusual standard may focus on the characteristics of the weapon itself.
And then you go into more case law.
And then dangerous and unusual. Let's see. Having considered the competing jurisprudence, we assume without deciding that the dangerous and unusual standard is distinct from the common use standard. That said, we conclude switchblades are not dangerous and unusual weapons falling outside the protection of the Second Amendment. In the most basic sense, all weapons are dangerous because they're designed for the purpose of bodily assault or defense. It's interesting. As such, general dangerousness of a weapon, i.e., irrelevant, where the weapon belongs to a class of arms commonly used for self defense. Consequently, spring loaded folding knives cannot be categorically prohibited just because they are, in everyday terms, dangerous. At the very least, for purposes of this analysis, quote, dangerous weapons must feature uniquely dangerous qualities that are disproportionate to their use for self-defense. Not if standard for dangerous, blah, 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 blah.
So I'll just go down here. All right, Rich, take over.
nothing about
the physical qualities of
switchblade suggests they are uniquely dangerous. A switchblade is defined as a pocket knife having a blade spring operated so that the pressure on release of the catch causes it to fly open. Quoting Webster's Third International Dictionary, 2314, obviously that's not a year, 1971. In a closed position, the blade is restrained by a latch or a lock. When the user presses the button, the latch is released and the blade is automatically springs open and typically locks in the open position. Olson knives, the second. Oh, Olson. Is that somebody we know?
No. No relation.
No
I'm not sure
relation.
where I am. Spring loaded, operated.
The Commonwealth has not presented.
Oh. The
All right, Dark,
Commonwealth
take
has.
over.
No, that's okay. Rich can get his chance. Or, you know what? Rock, paper, scissors. No, best 2 out of 3. Just one. You gotta do rock, paper, scissors, shoot. Okay. Rock, paper, scissors, shoot. You can't. You were waiting.
I'm
delayed,
going to
digital
do it. I'm going to do it. The Commonwealth has not presented any evidence to show why spring-operated mechanisms that allow the user to open switchblades with one hand make switchblades uniquely dangerous when compared to the broader category of manual folding pocket knives. Certain, like handgun switchblades, are particularly suitable for self-defense because they are readily accessible. It cannot easily be redirected or wrestled away. All right, Dark, go.
As an alternative to ordering the dismissal of the dangerous weapon charge, the Commonwealth requests we remand this case to the trial court for further factual development in light of Bruin. The Commonwealth argues this case could benefit from a more robust evidentiary record, or whether and to what extent state and local governments regulated knives during the founding and Reconstruction eras. We disagree. The Commonwealth has not explained what further factual development necessitates this relief. What? Oh, necessitates. Sorry, this relief. It is unclear what, if any, historical regulations can be unearthed should the Commonwealth be allowed additional time to develop the record. Indeed, despite having the full benefit of Bruin throughout this appeal, the Commonwealth has failed to identify a single on-point historical analog from the time of the founding, or at least the time the 14th Amendment was ratified. We therefore decline to remand.
Okay,
We
basically what the
reverse the
Commonwealth
order.
is saying that, we need more time. So go ahead and refer it back to it so we can have more time.
That's ridiculous.
In other words, give us a mulligan.
Yeah, basically.
We reverse the order denying the defendant's motion to dismiss, the defendant's admission to sufficient facts on the charges vacated, and judgment shall enter for the defendant on that offense. So ordered.
Okay, basically this is the Massachusetts Supreme Court, which is the highest court in Massachusetts. So this case is over.
Beautiful.
There's nowhere to appeal to.
Okay, but the California ruling on switchblades was what court? That was
a
Ninth
federal
Circuit.
district court.
All right, so this is state versus federal, so it's not a circuit split or anything like that.
No. This is a state court.
So basically, the law of the land stands for the rest of the country, the Ninth Circuit decision, whereas in Massachusetts,
that was a district court decision with a Ninth Circuit court decision.
I'm sorry, district court decision. Where in Massachusetts,
it's a district court. That's right now the California law stands.
right, except
Not
in Afghanistan.
Yeah, no, that only applies to the California law. Doesn't
Right.
apply anywhere
Okay.
else.
Well, okay then.
It's an interesting thing because back, in the founding era, the thing that was so interesting and unique about things like folding knives and switchblades and things like that, gravity knives, that there's a bunch of knives that were being, we'll call it invented and even, things that were just being tried by individual inventors and companies. If you were to carry a 6-inch knife on you, that thing was usually a foot long or so. The cool thing or the interesting thing or convenient thing, because look at all the pocket pistols, pocket pistols that were coming out around those times. They wanted to make things as bearable as possible. So if you had a fixed blade with a 6-inch blade, that thing was close to a foot long. If you have a folding knife with a 4-inch blade, you can usually fit that in a 5-inch package with a switchblade style or what. And I've handled very, very, very old switchblades, but it was a convenience factor for bearing them on your person. And that was always, especially around that time. Look at the crazy things they were making, like the pepper box revolvers, the all sorts of things were being made specifically for the purpose of being more convenient to bear on your person.
Yep. All right. So this is a good victory here. This is going to set up a lot of other challenges in Massachusetts and stuff like that. I do want to go and look at some of the comments I bookmarked here.
Yep.
When the government loses these cases, why do we get no recourse? They should be held financially responsible for the rights they've denied.
Yep.
There, you can get recourse. It's just highly unlikely because the judges are not likely to issue legal costs. I mean, every case has a legal cost, but usually the judges are not likely to make the government pay back. So
That's the ridiculous thing, though. It's like, these types of things occur, and let's say companies end up having to, get in a fight for their life, and they end up either almost going out of business or going out of business due to lawsuits. It's insane. There should be some type of way that they can,
I think
whether it's
I think we need an anti-slap federal law.
mm,
SLAP is a strategic lawsuit against public participation.
yeah,
Basically, when you sue someone just to shut them up or
yeah.
stop them from doing something you don't like.
That's
So
where the term "I'm going to slap a lawsuit on you" comes from.
yeah. Okay. We got another comment here. And a Duckkin says he has a couple here. What about butterfly knives? I live in Worcester, Massachusetts. I think this case sets up a challenge for that. Switchblade
Uh,
Switchblades are all knives. Well, this particular case dealt with knives that fold.
yeah. I
California case mentioned 1.2
So
switchblades
there's double
manufactured.
folds.
Yeah, California case mentions that 1.2 switchblades are manufactured in the U.S., which makes them easily common used items. I agree 100%. The judge tried to shoehorn by adding for self-defense in there. And that's how the judge justified and was able to dismiss the common use thing in California. Only applies to them, correct? So maybe, but this sets up legal challenges. Q Switchblade on the next list being described as MVEs. Yes,
Yep.
I think you're right.
His username is Anecdotin. That's witty and creative.
You can
'Cause
sue for civil rights violations. You can, but it's going to be a long shot to win, though.
yeah, the likelihood of you winning that is going to be
Not saying that your civil rights weren't violated. It's just knowing the way the courts work. So unfortunately, the chances of you winning that is fairly low. I don't think it would be worth it.
just remember if you talk about the Second Amendment, you are going to be considered a militia violent extremist.
Exactly.
Not exclusive to that, but maybe that included with some other things. Maybe.
Yeah. It's just
That document is insane. Sorry.
Yep.
I literally have like 20 switchblades in front of me, which is just funny.
All
There
right.
is no reason that these should be outlawed by anyone in any state. There's no real benefit, or yeah, sorry,
Well, I
different
think
topic.
we're gonna go ahead and get out of here. And just move on and wait for the next story to break, which I'm sure it will. And yeah, I'm gonna go back to sleep.
Have a good nap. Thanks everyone for tuning in. Appreciate you. Thanks, John, for sharing the news, and thank you for not
Where was somebody get
waiting.
extremely cool knives?
Definition knives on the 15th of September. Also,
Hey, thanks, John.
we are still raising money for the Cub Scouts. There is a link down below in the description, and I will put it in the chat. If you want to throw a buck or two to the Scouts, it would really help. Scouting has gotten really expensive, but it is still really good for the kids. So if you want
Yeah.
to help, maybe help some kids that are less fortunate be able to attend, you can go ahead and and that's the document right there. But you can go ahead and go to givesendgo.com/997. So I'll link that one more time since Rich wrote my thing.
And I would encourage you guys to do that because you could seriously have a tremendous impact on kids' lives that are less fortunate, that may not be able to afford going into Scouts. You could keep kids off the streets and getting into some trouble, and it's a really good thing. So just blessing others is always an important thing to do.
Yeah,
And
I donate money myself. In fact, all revenue coming from any type of advertisements I take or any type of YouTube revenue, it's all for the rest of the year. It's all going to the Scouts.
nice. Well, I also want to take a moment to highlight, like you mentioned, definition knives. I do just want to say that the knife that we made here for really paying homage to Crump, this is called the Journalist, and this will be available on 9/15. And maybe what we can do is work something out to where like a percentage of the profit from these goes to the Scouts or something like that. I think that would be something really cool. Definitionknives.com. Although it exists, it's not public yet, but you can go to Instagram and follow Definition Knives, all one word, no spaces, and that's where you'll find us. And shout out to Crump for being an incredible journalist, which is what inspired this knife right here.
Thank you. Thank you. All right, guys, that's it. I will see you guys later and have a good evening and stay ever free, stay ever vigilant, keep in the fight. I have another leak that's going to be coming out in about a week, so just letting you guys know.